Ladies and gentlemen, dear friends, dear colleagues, good afternoon. This is an IAI event on the influence of the French legal thinking in the field of international arbitration. And we are extremely privileged to have Justice Loh from the Supreme Court of Singapore with us. He will address the Singapore system and how it has certain links as to the case law on important issues with French law. And Justice Dominique Hascher will present the case law, and I will give some comparative law perspective. But before that, Madame Le Bâtonnier will also make certain remarks as to the importance of Paris as a place for arbitration, which is no surprise to most of you, and but which is still a constant effort and extremely important. So, Madame Le Bâtonnier, the floor is yours, and we'll discuss mostly in English and a little bit in French as well.
Okay, thank you very much. Some words in French, if you agree. C'est un immense honneur pour moi, bâtonnier de Paris, que de vous accueillir dans le cadre de Paris Arbitration Week, que nous avons ouvert avec une première conférence lundi matin sur les chambres commerciales internationales que nous avons créées et qui sont opérationnelles, qui était la question, est-ce un territoire à conquérir pour les arbitragistes, qui nous a donné lieu à des débats passionnants lundi matin à la Maison du Barreau. D'avoir le plaisir d'accueillir les personnalités, les hautes personnalités qui sont présentes, et je ne vois que de hautes personnalités, puisque c'est un véritable succès que cette 3e édition de Paris Arbitration Week, avec des confrères et des juges et des arbitragistes du monde entier, ce dont nous nous réjouissons. Paris place de droit, bien évidemment, Paris une des premières places d'arbitrage dans le monde, pour ne pas dire la première place d'arbitrage. Bien évidemment, c'est aussi tout le développement dans le contexte de Brexit que nous connaissons. Et c'est d'ailleurs dans ce contexte que nous avons créé les chambres commerciales internationales de Paris, qui sont d'ores et déjà opérationnelles. La Cour d'appel de Paris a déjà plus de 20 cas, grâce au président François Ancel, qui sont tous des juges qui parlent couramment anglais. Vous savez que désormais, vous avez la possibilité de plaider, si vous le souhaitez, dans une langue étrangère. Bien évidemment, nous commençons d'abord par l'anglais, du fait de la perte de l'exéquatur des décisions de la High Court. Je viens de m'en entretenir brièvement avec le représentant de Singapour. Nous avons prévu d'ailleurs un événement à l'ambassade de France à Singapour, puisque nous sommes en compétition avec nos chambres commerciales internationales à Paris et les chambres commerciales de Singapour, qui sont aussi opérationnelles. Voilà, donc c'est une véritable dynamique dans le cadre de l'arbitrage. Vous prenez également naturellement le droit français et le droit continental, qui nous avons fait à Abidjan un grand campus international sur regard croisé sur la médiation et l'arbitrage OADA, qui a été un véritable succès, et qui est que comment est-ce qu'avec nos systèmes, nous pouvons encore davantage nous enrichir et développer ensemble des business. L'attractivité de l'économie par le droit, c'est ce que je plaide depuis le début de mon bâtonnat. C'est grâce à vous, grâce à tous nos avocats internationaux qui sont à Paris. C'est la diversité, la richesse de notre barreau que d'avoir et que d'accueillir toujours, et vous serez tous les bienvenus, mais de toujours accueillir des avocats du monde entier, des juges du monde entier, des médiateurs, des arbitragistes du monde entier, et votre place, ce barreau est le vôtre. Sachez-le, il vous sera toujours ouvert de façon à développer justement la place à la fois du droit continental, à la fois du droit français, mais aussi tout simplement de développer notre practice. Je remercie à cette occasion, parce qu'elle m'est rarement donnée, tous nos avocats du barreau de Paris, parce que pour leurs compétences, pour leur réputation et justement pour toute leur activité, le développement et la richesse de nos cabinets internationaux, quels qu'ils soient, c'est toujours un plaisir. Je me réjouis par conséquent de l'immense succès, puisque pour ceux d'entre vous qui étiez là lundi soir au Conseil économique et social, je disais, j'étais très impressionnée avec ces milliers d'arbitragistes, avec un Conseil économique et social qui était absolument complet. Et je ne peux que vous souhaiter que d'excellents travaux. Je me permettrai juste un point encore, qui soit de dire que cette activité, nous la développons non seulement dans l'arbitrage international, non seulement dans le contentieux commercial international à Paris, mais aussi, vous le savez, la juridiction unifiée des brevets, puisque de grandes discussions se tiennent actuellement et il est prévu que le siège social de la juridiction unifiée des brevets soit implanté à Paris. Et puis également l'agence européenne bancaire que nous avons inaugurée le 9 mars dernier. Nous sommes en pleine actualité. Voilà, de vous souhaiter encore une fois la bienvenue dans notre magnifique palais de justice. Vous avez 3000 ans d'histoire dans ce palais de justice. Je sais que vous venez de le visiter. Nous avons maintenant un nouveau tribunal qui est extrêmement moderne. Nous sommes aux deux opposés. Et donc la prochaine fois, lors de votre prochaine visite, nous vous organiserons une visite au nouveau tribunal de Paris. Au nom de l'Ordre des avocats de Paris et de tous les avocats de Paris, je vous souhaite la bienvenue et une excellente conférence, en remerciant encore l'Institut d'arbitrage et également le cabinet Sherman Sterling qui ont organisé, en coordination avec l'Ordre des avocats de Paris, cette conférence. Merci à tous.
Merci Madame la bâtonnière. Avant de passer la parole au juge Dominique Hascher, je voulais rappeler que vous êtes dans cette salle, vous représentez plus de 50 pays, j'en ai la preuve ici. Algérie, Argentine, Australie, Azerbaïdjan, blablabla, ... Suisse, Tunisie, Turquie, UK, Ukraine, USA, Ouzbékistan, Venezuela. Donc j'en ai sauté quelques-uns, mais la preuve est là, vous pouvez la consulter en sortant. Donc c'est l'immense attractivité de la place qui est déjà reflétée dans votre participation. And now we are going to discuss the issue of the influence of French law in the world regarding the field of international arbitration. And Justice Dominique Hascher is going to first present the salient features of French law on arbitration, which are known to many, but just as a recap and to see the spirit in which the Court of Appeals of Paris and then the Court of Cassation has developed that case law. And then I will give some elements of comparative law, and Justice Law will zoom on Asia and in particular on Singapore. So, Dominique, you have the floor.
Thank you, Professor Gaillard. The influence of French legal thinking on international arbitration, I think the least that we could expect is that French legal thinking has had and still has an influence on French international arbitration law. But the first question, of course, to ask is why did you have in the title of this conference international arbitration? Well, let's have a quick glance at the past. First, we have to note that there was a complete destruction of arbitration by the Supreme Judicial Court in the first half of the 19th century. And after the rulings of the Supreme Judicial Court of France, there was only room for a submission agreement. And when I have to say room, I should say some room only, because submission agreements were only valid provided they met with the stringent conditions that had been laid down in the Code of Civil Procedure of 1806, that is, at times that did not favor particularly the blossoming of individual liberty and self-government. Now, it's only under the pressure of economic reality that the strangling of arbitration agreements was gradually relaxed in the first half of the 20th century. First, the legislator admitted valid arbitration agreements in commercial matters. But with regard to the French courts, you must have in mind that in the French view of the separation of powers, there is no judicial review that can exist, and that therefore the room of maneuver for a judicial pro-arbitration policy is extremely limited. And creativity can only take place in fields that are unregulated by the national legislator, such as international legal relations. Now, this background, which I have just very rapidly summarized, explains that the definition that we have of international arbitration relies on a quite supple economic criterion, which is only that of the involvement of international trade interests. Now, this very flexible approach was recommended by legal scholars as the only one that could favor the emergence of an ad hoc legal regime for international arbitration, and that legal regime would be made of self-contained rules. And this is what I will now be dealing with. A revolution, a good one, occurred in the 1960s in this building, not here, but further down there. Instead of identifying the governing law, the Supreme Judicial Court directly decided that an international arbitration agreement between a French party and an Italian party is separable from the underlying contract. Well, you bear in mind that in the 1960s, at the time, French law superbly ignored separability, although this was already an accepted principle in the arbitration law of many of our neighboring nations, including Italy, where, in this precise case that I'm referring to, the seat of arbitration was situated, and Italy accepted separability of the arbitration agreement since the 1930s. Well, this is how autonomy, I'll be back to this notion in a few moments, not only of the arbitration agreement from the contract, but also from national legal rules began. The repudiation of any conflict of laws analysis consequently results in the exclusion of national laws. When I was referring to this case of the 1960, you see that the Supreme Court did not look at French law. Well, there was no use of looking at French law anyway, because otherwise there was no separability. But it didn't look at Italian law also. It just laid down a rule that said there's separability in a contract where, in an international contract, where you have an arbitration agreement that was made without reference to any law that might have applied to this issue. So, that tells you about the approach adopted by the French courts to decide arbitration issues. Because the solutions that are provided by the applicable national law is not taken into consideration by fear that they would be ill-adapted to the needs of international arbitration, the disputed issue is therefore resolved directly by the judge by rules that we call, or that are called in private international law, I mean it's not specific to international arbitration, but they're called substantial rules of law. Why? Well, that's inasmuch as they provide a solution on the substance of the unresolved issue at stake. Well, this is how we embarked on a quite long journey of drafting specific rules for international arbitration. We were encouraged by academics and practitioners to develop the substantive rule law approach, and it more particularly matured as regards the arbitration agreement, and I will limit my intervention to arbitration agreements. So it more particularly matured, I was saying, in 1999 by a judgment of the Supreme Judicial Court that laid down a principle, if I being translated into English, that says a principle of validity of the arbitration agreement, which you must understand as opposed to any contrary rule in national law invalidating such arbitration agreement. What also you have to know is that the law, the national law, which was avoided in 1999 by this judgment, was the French Civil Code. Because at the time, what did the French Civil Code say? Exactly the opposite of the judgment. It laid down a principle of invalidity of the arbitration agreement. Now, if you adhere to a theory or that an arbitration clause should, as a principle, be considered as valid, it tells you also a lot about, first, the preference given to arbitral tribunals for deciding on all disputes regarding the arbitration clause. It also tells you about the related obligation for courts to withhold their jurisdiction to decide these issues. By recognizing this, we simply assume that arbitration is not a derogation from the norm of adjudication in a state court. Well, you may find it perhaps that this is a mundane remark, but it represents, for judges here, a significant cultural voyage than to recognize that judges have no monopoly over justice. Now, since the end of last century, I mean the 20th, the principle of validity, which should be regarded as really the keystone of French international arbitration, harbors a number of subordinated rules for the interpretation, the ethics, the application of the arbitration agreement. Now, this leads to the complete disregard of archaic solutions such as prohibition of arbitration by state entities, commercial nature of the underlying transaction, or the requirement of a specific mention of the arbitration clause which is embedded in another contractual document, such as a bill of lading, etc. Now, this has also been particularly important for enforcing arbitration agreements against non-signatories and for assignment of the arbitration agreement. The rules that have been developed posit that the parties who enter into an arbitration agreement expect to be bound by its terms and that the national court is satisfied of the existence of such agreement and consent also of the parties to arbitration, which is simply inferred from the parties' involvement in the negotiation, performance, and termination of the parties' contractual relations. Now, of course, the most regressive quarters of French academia have denounced the imperialism of solutions crafted by the French Supreme Judicial Court, since, as you will see, or have you seen, any governing law, including foreign law, is not applied by the French court. Well, I think that this opinion is simply not acceptable, certainly. Why? Well, because French courts only apply their rules whenever they have jurisdiction over an arbitration or over the dispute. And the question of the international reach of the substantive rules is not a question which is addressed to the French courts. It's rather a question which is addressed to non-French courts or to arbitrators. Under a conflict of law approach, a foreign court may well find that French law is applicable. Well, if this is the case, then all what the foreign court has to do is to apply the substantive rules which the Supreme Judicial Court of France has fashioned for international arbitration. But may I also add that there is nothing as self-validation. The validation principle, which I have referred to, cannot be separated from the work of the court to bring the arbitration agreements in its legal order, which means that from the viewpoint of a French court, the application and effects of an arbitration agreement are of course subject to French international public policy, that is, that they are not contrary to these principles. Now, nothing should of course prevent a foreign court from adopting the same approach than the Supreme Judicial Court of France towards international arbitration. If they do so, then this would mean that instead of applying French law or any other domestic law, pursuant to a conflict of law approach, a foreign court would, just like the French courts have done, answer the disputed issue directly by laying down a substantive rule. And I would guess that such a substantive rule will have a tenor that should not be very different from the French substantive rules of international arbitration. And I will now explain why, in my view, this should be the case. We may certainly have a lot of questions as to the legitimacy of judiciaries to carve out rules of their own. We may ask ourselves, certainly, if under the cover of legal principles, judges have not, after all, just donned their magician robes. The repudiation of national laws to regulate international arbitration is only justified if the judge-made rules achieve better efficiency than national rules by being more responsive to the perceived needs of international trade. Now, this is the case if the substantive rules that are fashioned by the courts are inspired by the practice and the decisions of arbitrators. In this sense, I would say that French international arbitration law is inspired by a consensus on best practices in international arbitration. A decreasing number of UNCITRAL model law legislations has gradually enhanced the number of pro-enforcement legal regimes in arbitration. The situation today is no more internationally that of the 1960s, when the French Supreme Court launched an autonomous regime for arbitration, which was based on the avoidance, once again, of the pitfalls and retrograde conditions found in many legislations at the time, including, first of all, French law. Now, the approach of the French courts remains justified by the rejection, certainly of traditional prohibitions to arbitration. Of course, as I said, they may have waned today, and therefore, if we are just looking at this, we could perhaps say that we consider here in France, particularly at the French Cour de cassation, that we consider that some foreign judiciaries are not still able to understand the proper standards that justify the enforceability of arbitration agreements. Well, I do not think that our continued adherence to a non-conflict of law approach is dictated by any position of superiority. We are looking, I think, to justify our approach still in the 21st century to a number of guiding assumptions. And these guiding assumptions have been developed by French legal thinking on international arbitration. And these guiding assumptions, in my view, include the acceptance of the existence of the plurality of legal systems, the recognition of the existence of an arbitral legal system, distinct from national legal systems, as acknowledged on numerous occasions by the French Supreme Judicial Court, which ruled that awards should be considered as decisions of international justice whose validity is not only determined by the requirements of the legal system of the seat of arbitration. These are, in my views, the first guiding principles that we are following. And the third one, which is perhaps a more domestic French concern, is that we are also working by laboring with substantial rules of law to limit the foray of the French legislator into international arbitration. This is all what I had to say. Thank you.
Thank you, Dominique, for this fascinating presentation, and I'm sure we'll have questions, and there is time for questions. I will just give some comparative law perspective to this. Before I do that, I just would like to stress the fact that French law on arbitration has always been created by the judge. It's true that we have a very modern statute in 1981 and an even more modern statute on 2011, but for the most part, it captures, it explains, it describes what the judges have done in France to promote international arbitration. And it's true that possibly the academia has guided, has discussed with the judge, but we must recognize that it's a judge-made law codified subsequently. And that's very important. And the judge can help arbitration in two different ways. And if one doesn't understand that, one does not understand the divide in the world about arbitration. Everybody wants to help arbitration. But there are two ways to try to promote arbitration. The English way is I want to help arbitrators. The courts are here, the best court in the world, according to some, to help arbitration. So if you need anti-suit injunctions to protect, because someone is trying to negate the clause, you should arbitrate. I'm going to help you. I'm going to enjoin someone not to litigate elsewhere. I'm here to help you. That's one policy, very respectable. That explains the English view vis-à-vis arbitration. It's a way to promote by helping. The French courts have long developed a different vision. They say, we are not here to help you, we are going to protect you against any interference. It's the exact opposite. Any interference, including our own interference. So you want us, you litigant, want us to interfere at the beginning, we can appoint an arbitrator if need be. That's it. Then you're on your own. Oh, something is going wrong in the middle of the arbitration. Come back with an award. We intervene at the beginning to set up the tribunal, at the end to control the award. In the middle, protection. No interference, no help. We are not here to help you. We are going, at best, to help you to avoid any interference, including our own. So it's a very different way to try to promote arbitration. No help, no interference. So it's a very different view, which both are valid and legitimate, and it's simply a different policy. And that explains the divide in the world. Now, the second remark is that the history of international arbitration in France and in the world is the history of fighting against dirty tricks which the litigants have invented. And each time you have a rule which is very well established in the field of international arbitration, each time you have a history of litigants trying to derail arbitration in a way or another because they are defendants, they don't want the arbitration to go so well because of the interest of their clients, and they have developed ideas to try to hinder, to hijack the arbitration process. And the history of the rule is an history of the responses the judiciary, principally, has developed to protect arbitration. Not to help arbitration, we are in the French logic to protect arbitration against any kind of interference. To concentrate the powers, except at the beginning, except at the end, on the arbitral tribunal. I take 4 examples, and in the history they are not equivalent. Some are very old, some are recent, and some are forward-looking. The oldest is the rule of the autonomy of the arbitration agreement. The trick there was, the contract is void. I may prevail. I'm saying the contract is void because you didn't respect the right conditions, and therefore the arbitration, which is clause 27 of the contract, is void as well. But you cannot decide that because you have an arbitral tribunal. If I'm right, that is void, clause 27 is void, the arbitration agreement. Therefore, everything is void. I will discuss that before a real judge, a court. Answer? No. There is a fiction which has been created saying the arbitration agreement, my clause 27 in my example, is independent. It's a fiction. It's legally insulated from the rest of the contract. So if you're right that your contract is void, arbitrators can say that, and that will not voiden the arbitration agreement itself. Everybody knows the rule. And that is the answer to dirty trick number 1. Now, in terms of history of ideas, this has been adopted by the French Supreme Court in 1963 in the most famous decision on arbitration, Gosset. Now, the English lawyers, with respect, which I love, as you all know, it's an old debate we have thought hard about it. And in 1993, 30 years after Gosset, they said, yes, the arbitration agreement is independent. It's now constantly accepted in English law. It's Harbour versus Kansas, Court of Appeal, 1993. And it was saluted by the press as a great step forward to protect international arbitration. The arbitration clause is independent from the contract. This law has been a few years before, in 1985, adopted by UNCITRAL. The UNCITRAL model law accepts this principle of autonomy or independence or separability of the arbitration agreement from the main contract. And this is a rule which is probably the most unanimously adopted in the field of arbitration in the world. This is the almost total unanimity. Every set of rules on arbitration, every law on arbitration, even mildly favorable to arbitration, accepts that. This is rule number one of international arbitration. That's how it was developed, and today it's unanimous. So thank you, thanks to Gosset, thanks to the Court of Cassation, your predecessors. This was a huge success in the world. Rule number two, that does not deter the litigants to try to find other dirty tricks. If I say the contract, the main contract is void, therefore the arbitration agreement is void, the therefore does not work. So I'm going to say the arbitration agreement is void because you never consented. I don't know what the ICC is. It's far, it's in Paris, I don't know. I never consented. The person who signed the contract has no power to sign the arbitration agreement. So I attack the arbitration agreement, but you, arbitrator, cannot decide if it's right or wrong, because if I'm right, I could be right. If I'm right, you prejudge. Cannot do that. It would be a breach of logic. Now, the answer to that is the principle of competence. Arbitrators, when their jurisdiction is challenged, have the power, the competence to decide on their own competence. In terms of comparative law, it was adopted by the French courts in Impex in 1971, so it's not a new rule. Thanks again to the French courts, absent any legislation. And I have to confess that my predecessors in the role of lawyers and the role of professors have played a little bit of a trick by saying it's the principle of competence with KZ twice. It's German, it's serious, it must be adopted. You don't know why, but it's competence, and it's well known. It's adopted in Germany, and that works. But the French court said, if it's German, it must be good. In any event, it protects international arbitration. Therefore, let's accept the competence principle. I say it purposely in French, because German law does not recognize competence. The Germans are way too logic to accept that, and they say, competence. But if it's a petition of principle, if you ask competence, if the arbitrator is not competent, they cannot say I'm not competent. So you cannot say it's not logical, and it's very puzzling for a German mind because they are too well trained. The French are more pragmatic, as we know, and say, okay, but it's good for arbitration, we like it. That's the story of this rule. Now, historically, this power of arbitral tribunals to decide on their own jurisdiction is also now virtually unanimously accepted. It has been accepted by the model law in 1985. You see the channels, the model law, we develop some ideas, and then it's propagation du droit savant. It's something which is influenced through the UN, and then it's adopted in 80 countries or what. So now it's pretty unanimously accepted. Even Germany, I'm glad to say, at long last, after having thought hard about it, adopted this principle in 1997. It's now Article 1040 of the ZPO. Good. It's almost unanimously recognized, almost as good as the principle of autonomy of the arbitration agreement. Dirty tricks number 2 does not work. No problem. I will invent dirty trick number 3. Is, okay, you have competence, okay, competence, or call it competence de la compétence, or competence. In any event, arbitrators, you can decide. Fine. But, in the same time, I'm going to seize a judge, a real one, a good judge. My judge, at home. And the judge will say if the arbitration agreement is good or bad. And if it's good, I lose, I appeal. But if it's bad, I present it to the arbitrator or to any court to resist enforcement. I will bypass you. Haha, compétence de la compétence. It's not very useful because I can engage in a race and go to a court. That's not good for arbitration. So this is a rule which is a bit more controversial today because we don't have the same kind of time passing by, but I'm still hopeful. And the world is divided into 3 blocks with respect to this rule. So it's not unanimous like for the first 2 rules. The first camp is the camp saying, we don't like this. Judges, when they are presented with a case and they would have jurisdiction, they can decide fully on the validity. And someone says, no, you should go to arbitration. There is an arbitration agreement, but it's challenged. The court should decide fully on the existence, validity, scope of the arbitration agreement with the full apparatus and appeal if need be. And you have a court deciding that in the first place. Guess whom? The Germans, so shouldn't use the word competence too much. Not only they say that, but they locked the decision by adopting the model law wholesale, except on one sentence saying, but the courts, to make it clear, the courts can decide fully on the existence and validity of the arbitration agreement if that's challenged at the beginning. So it's not prima facie there is an arbitration agreement, go arbitrate, I will intervene at the beginning and at the end. That's it. And that's the rule, camp number 1. It's unfortunate. The German law on arbitration is good on every other account, not on that. The second camp is the American camp, and it's very idiosyncratic. They have a rule which no one else uses in the world, and with their own terminology, what they call arbitrability, which is not arbitrability the way we use arbitrability, which means scope, validity and scope of the arbitration agreement. So you have to translate their own legalese. So what they call validity, what they call arbitrability, validity and scope of the arbitration agreement is decided by the judge, just like in Germany. But they are a bit more favorable to arbitration because they say, but this power, which is typically a judge power, can be delegated to an arbitral tribunal. But if you do that, it has to be done through quote-unquote clear and unmistakable delegation of powers by the parties to the arbitral tribunal. So you take that power from the judge and you give it to the arbitrators. That can be done by rules when the rule says arbitrators can decide on their own competence when this competence is challenged. That's a clear and unmistakable way to take this power from the judge and give it to the arbitral tribunal. So that's why in the US you need to have an arbitration agreement, and then the second clause saying it's a real arbitration agreement, we really meant it, and we meant to give the competence to the arbitral tribunal. In that case, if you have these magic words, either in the contract to arbitrate or in the rules, then this power is taken from the judge and given to the arbitral tribunal. I say, this is great for arbitration. This is a bit formulaic, like in the Roman law, you have to have the right language, if not, it doesn't work. But it's a bit too much and a bit too little. It's a bit too much because when this power is given, it's given for good, and then you don't have a control at the end. And that's a bit of a problem, because if you find the magic word somewhere in the rules, then the power to control the arbitral award is taken for good from the judge. In other legal systems, like in France, it's taken at the beginning, it's prima facie. At the end, it's a full control, because you have to have someone saying, yes, they agreed to arbitrate, right? You cannot say they agreed to arbitrate and agreed to give that power to the arbitral tribunal, but even if the agreement doesn't have the scope too bad, the arbitral tribunal will decide for good with no review. So it's a bit too much, a bit too little, but we cannot say that the US law on arbitration is not pro-arbitration. It's another way to be pro-arbitration. It's another policy, which I personally think is misguided, but it means well. Interestingly enough, for those who like politics, the last decision on this principle has been rendered on January 8, 2019, and it's the first decision by Judge Kavanaugh, very famous for other reasons, which I will avoid discussing at length here, although it's quite interesting. And he rendered a very pro-arbitration decision, saying, because one of the arguments by the litigant was, well, yes, it works because it has been adopted by first options as early as 1995, but not when there is a wholly groundless case. So they wanted to have an exception saying, well, this power can be delegated unless the case in favor of the validity of the arbitration agreement or scope of the arbitration agreement is wholly groundless. And they said, no, pro-arbitration decision, unanimous decision, written by Judge Kavanaugh, saying pro-arbitration, first options work, except that they leave open whether, two questions. One, whether the rules saying arbitrators can decide on their own jurisdiction are a clear and unmistakable evidence of this delegation. Question one, open. And question two, which I raise, which they have not formulated that way, which is they seem to accept that for the scope of the arbitration agreement, query, does it apply also to the validity of the arbitration agreement, because they seem to have missed this nuance. Anyway, the scope of the rule is quite uncertain, but it's an attempt to mean well and to protect arbitration in a certain way. The way French courts have protected international arbitration is a third way. It's the logic, it's to push the logic to the full extent, the logic which I expressed a moment ago. At the beginning, we can set up the arbitral tribunal if need be, if you need help. We are not going to control the existence and validity of the arbitration agreement. Come back at the end of the process. If you have an award, if the arbitrators can decide lots of things, they can decide public policy issues, corruption, antitrust, whatever, they can decide the scope and validity of the arbitration agreement. It's not more serious than any public policy issue. They can decide. I will control at the end. In most cases, they will get it right. If they get it wrong, I'm here at the end. The beginning is prima facie, the end is full control. And it's not, I delegate it, it's a full control here, which I can put full control there and abandon it. It's, I look at it prima facie, and I control at the end. The policy is very clear, very pro-arbitration. Now, what has been done in other jurisdictions in the world? The problem here, with all due respect to UNCITRAL, is that UNCITRAL has been a bit lazy on this field, and they just copied the New York law, the New York Convention test. So in many UNCITRAL law jurisdictions, it simply says courts, before which an action is brought in a matter which is subject to an arbitration agreement, shall send the matter to arbitration, unless, and this is the language, it finds that the agreement is null and void, inoperative, or incapable of being performed. And you all recognize Article 2 of the New York Convention, drafted in 1958. And in 1985, they simply copied that, instead of rethinking the matter, rightly or wrongly, probably rightly, because if it's to do worse, it's better to leave it as is. But that's the text for 80 countries, pretty much. Now, what these countries have done, the test, is it, unless it finds it's ambiguous, unless it finds prima facie, French style, or fully, after a full review, more Germanico. It means like the Germans, right? So you can control fully or simply prima facie. And what I find very interesting and very interesting for what French law has done to the world in the field, is that many laws having this textual basis have gone out of their way to be pro-arbitration and say, yes, but this test will be prima facie. And I'm not going to discuss Singapore, but I just want to throw a few examples quickly. Latin America, Supreme Court of Venezuela, November 3, 2010. Argentina, National Court of Appeal, October 28, 2009. September 8, 2015. It has been codified in Argentina. It has been codified. It has been adopted by the Constitutional Court in Colombia. It has been codified in Colombia. If you were to do the list in Latin America, half of the countries have accepted the principle, prima facie control only. In Africa, OADA has adopted wholeheartedly the rule. It was adopted before, but it has been recodified in 2017. It's Article 13 of the OADA law. In Asia, Supreme Court of the Philippines, Shinetsu, Supreme Court of India, Hong Kong, Singapore, we'll see in a minute. So it has been, these prima facie tests to resist against the race to a favorable court, dirty trick number 3, is expanding. And I salute that effort, and it's even in Switzerland, it's also recognized in some situations. There are nuances in Canada, but by and large, it's broadly accepted. Now then, dirty trick number 4. And this is work in progress, and here we have seen 2 rules which are very, very accepted, very widely accepted. A rule which is gaining traction, still not unanimous by far. I'm not hiding the fact that the negative effect of competence is not unanimous. There are three rules competing out there. Rule number 4, the creation of the arbitral legal order. This is also a way to resist against an attempt to manipulate the system by trying to exploit decisions ancillary, court decisions ancillary to arbitration, either at the seat or elsewhere, recognition decisions, and try to export those decisions to prevent recognition of the award later on, or to permit or to bypass recognition of the award by having the recognition of a recognition decision of the award. So litigants now are more sophisticated. They don't say, well, the contract is void, therefore the arbitration agreement is void, therefore doesn't work. They don't say, well, the arbitration agreement is void itself because you have the competence principle. They don't rush to court to prevent that because you have the negative effect. Say, okay, I will have a decision on an arbitration and I try to export it. And that's why, in a way which is possibly a bit too abstract, to be exported easily, the French court have said, no, I look at the award. Whatever decision ancillary to the award, even at the seat, will say, I don't care. I will recognize, my dialogue will be, just like it is with American law, with Indonesian law, with arbitration law, I dialogue with the award itself. In other words, I look at the award to know if the award is good or bad, and I don't have to give deference to another court having decided, rightly or wrongly, that the award is good or bad. Why? They want enforcement here in this country. Therefore, in this country, have certainly a legitimate title to recognize or not the award. And whatever they do elsewhere, I don't care. Because the reverse trend which we see developing in England in particular, and it's very troubling, is that now they seem to accept, and that will be the debate for the next 10 years, they seem to accept that a recognition decision somewhere, not even at the seat, a recognition decision of an award can be recognized in turn. I have to give deference. The French judge decided to enforce this award rendered in Russia, or the reverse. Therefore, they decided to recognize this award. Therefore, I will recognize the French judgment. and reasoning not on the award itself, but on decisions, court decisions ancillary to the award is a big danger, it's a big threat to arbitration. I don't think the courts in the world have always perceived that it is a dirty trick. The dirty trick is the race to the most favorable judge. I don't like arbitration. I'll go to a place where I think that they will say this award is not a good award, and then I'll try to export the judgment. I like the award. You can manipulate the process in the same way. I rush to France. I get a French decision saying it's a good award, and then I try to export it in the US, where the standard of review is way higher for an award, but for a decision it's lower. So I'm trying to manipulate the system. That's a bad thing. And when the French courts have said, as they said in a bit abstract way, we apologize for being French, the recognize an arbitral legal order, that's what it's meant. It's meant I look, it's a very simple thing, it can be expressed in concrete terms. I look at the award, not at judgments ancillary to the award, even at the seat. And certainly not elsewhere. I don't look at anything other than the award itself, because I look at, and that's the translation into French legal thinking, because the award is in an autonomous legal order. But you don't have to say that. You can just say, I look at the award as the primary material, which is the material which will be recognized in my country. Now here, this has been recognized by Putrabali in 2007, by Ryanair in 2015. So if you take Putrabali as the starting point, and if you consider that it took the Court of Appeal 30 years to accept the Gosset solution regarding the autonomy of the arbitration agreement, by my account, we have until 2037 to convince English judges to abandon their logic, which is I look at the decisions ancillary to the award, to focus on what the New York Convention wanted them to focus on, i.e. the award itself. Thank you. This concludes my remark on the comparative law analysis. Now, after this plaidoyer, Justice Loh will focus on the Singapore view of international arbitration, and you will see that Singapore has not been chosen randomly. Justice Loh.
Thank you. Good afternoon, everybody. First, it's a great honor to be here and a great pleasure to be in Paris. So thank you to the IAI for inviting me. Second, I really am very sorry, but my French is non-existent. And if I tried it, I think you'll all leave the room. Well, so let me tell you a bit about Singapore. We are a common law country, and Singapore is also a very small country. Our total land area is 721.5 square meters. So it's really small, and we have 5.6 million people. We have no natural resources. So historically, we've depended on trade, and therefore it is in our DNA to look outside our country, and we cannot remain insular. So we continue to look outwards not only in things like trade, we look outwards in terms of our law, especially in matters of international arbitration, because commerce and trade is very important to us. We read avidly of the developments in the law around the world, and I can assure you this includes France. And we try to learn and take the best from the different systems and adopt it, or maybe adopt it with a bit of modification to suit our legal circumstances. So in relation to international arbitration, we are a model law country, and we adopted the model law in 1995. Our legal jurisprudence, that means our court-made law, is also similarly outward-looking. Our academics also look outwards, and they compare to our decisions, to decisions around the world. And of course, quite often, they criticize what we do. I myself have rendered 2 decisions, say in the past 2 years, and some people have disagreed with it. But I say fine. The more debate we have, the better. So we also look outwards, and in many of our judgments, you will find that we actually cite foreign decisions. We even cite how the FIDIC enforces decisions of the Dispute Resolution Board. And we are also keenly aware that litigants, as Professor Gaillard says, have full of ingenuity to find new ways around all the newest rules, either to delay matters or to frustrate the other side getting their judgment. So let me give you some examples of how Singapore tries to frustrate them. Under Article 34 2B2, under model law, a Singapore court may set aside the arbitral award if the court finds that it is in conflict with the public policy of Singapore, the state. So public policy, you can read it broadly or you can read it narrowly. I once had dinner with a judge who was going to become the Chief Justice of the Supreme Court of India, and I almost fell off my chair and to keep my mouth shut when he said, well, if an award is wrong according to law, it is against our public policy to enforce it. I thought, wow, this one is going to put arbitration in India backwards again. But I think you'll be very happy to know he was only Chief Justice, I think, for about 2 years. And then the retirement age caught up with him and he left. So some of us, and some of you, I'm sure, breathe a big sigh of relief, especially those who have clients who do business in India. So in Singapore, when we look at public policy, we only take it as very narrow in scope. It is not necessarily Singapore public policy. So at one time when we had our Wagering Act, that means you couldn't put wagers on public bets and things like that. A question would come up that if a casino wanted to enforce a loan agreement with someone who gambled, what would the Singapore court do? Would they say, our law goes against gambling, so we're not going to enforce this? We said, no, we will enforce it because it is only matters which shock the conscience, which are clearly injurious to public good, wholly offensive to ordinary and reasonable people. It violates our most basic norms. Then only will we interfere on grounds of illegality or public policy. I don't know how many of you keep up with your reading of Singapore jurisprudence. We had an interesting case in 2011 called AJU versus AJT. We do that because we anonymize our law reports for international arbitration. Well, there were 2 parties who got into contracts, and what they wanted to do was to run a tournament in Thailand. As things would happen, they didn't agree with each other. They started fighting, and they also reported to the police about each other, and they started an arbitration. Halfway through the arbitration, they settled. So A and B signed a settlement agreement. Some had to do certain things, and A paid B, I think $500,000 US. But guess what? B decided he would not terminate the arbitration agreement. So there was another round of dispute. And they both agreed, right, let's settle it. Let's go back to the same arbitral tribunal to settle it. So they argued the case. They argued illegality. One of the things that A wanted B to do was to remove his police report, I think about forgery, because that was an offense in Thailand that could not be compounded. And they say by agreeing to that, I was undermining the administration of law because I would stifle police investigation into a crime. So the arbitral tribunal heard everything. They heard the arguments against illegality, and it ruled that the settlement agreement was valid. Arbitration proceedings were terminated. They were B was very unhappy. He came to Singapore and he started proceedings. And guess what? The trial judge, not me, reopened everything about illegality. And he said the arbitral tribunal was wrong. If the settlement agreement required one party to withdraw a complaint on an offense that could not be compounded, it would be illegal because you're undermining the administration of justice. You're stifling police investigations. So A took the case to the Court of Appeal, and the Court of Appeal actually upheld the arbitral tribunal. They said the two of you had full arguments before the arbitral tribunal. They were perfectly entitled to come to the conclusion that it was valid. And therefore, that was their conclusion. And whether that was an error of law or an error of fact, the court is not here to correct it. And so they said the High Court judge was wrong to reopen the issue, and they said the award stands. So that's an example of how far the Singapore court would go to respect the decision of the arbitral tribunal. Now, in Singapore, as Professor Gaillard has said, we adopt the negative effect of the doctrine of competence, which is the exclusion of the judiciary to look into objections of jurisdiction. So, routinely in the courts, when parties come before us, the first question we ask, where's your arbitral tribunal? Has it been formed? If it hasn't been formed, we say, go, you form it. You go and argue before your arbitral tribunal all these jurisdictional grounds. And if we have to really look at it, we do a prima facie review. It is not a merits review. So unlike some of the countries in the region, I believe Australia, Germany, New Zealand do a merits review when there's a jurisdictional challenge before the court. We say no. You go before the arbitral tribunal first, and we routinely turn these people down, or we stay the matter until the arbitral tribunal has made a ruling. So we also do it on two grounds. One, Section 6 of our International Arbitration Act says if there's international arbitration and there's an arbitration clause, the stay must be given. Not may, must. We must stay. We also have Article 8.1 of Model Law, which has the force of law in Singapore, which also says unless the court finds the agreement is null and void, inoperative, or incapable of being performed. So guess what? We have people coming before us to say, you see, I wasn't a party to this agreement. It doesn't involve me. Or they come and say, look, there's nothing to arbitrate. This other guy has admitted the debt. He owes me the money, so what's he fighting about? So I need to come to you. So they will never stop coming to us, and we recognize that. So all we do is we give a prima facie review. Is there an arbitration agreement? If it looks, well, maybe you may have taken over the agreement and the clause. We do a light touch, we send them off to the arbitral tribunal. We do not touch it. So if there's a valid arbitration agreement, that means on a prima facie review, the dispute looks like it falls within the arbitration clause. The arbitration agreement is not null or void. We say, off you go. And our Court of Appeal said it is really only in the clearest of cases that the court will say the arbitration agreement is inapplicable. So the prima facie standard is applied both to validity arguments and scope of the arbitration clause agreement. And it is only after they have finished with the arbitral tribunal, can they come to us. And we have the three routes they come to us. It's the model law, they go before the arbitral tribunal first. If the arbitral tribunal under model law decides it as a preliminary issue, then you have to come to us within 30 days. If the arbitral tribunal puts it as part of the main award, then you come to us after 30 days too. If you come to us under Section 10 at an earlier stage, then we may or may not listen to you. Our preference would be you finish with the arbitration first. So if you look at it, what do we have? First, you have the active remedy, right? Under Section 10, you come before us. If we find there's something that you can argue about, we might listen to you, but we also give the power to the arbitrator under model law to carry on with the arbitration. And then you have the active remedy under Article 34, when you disagree with the jurisdictional finding. And the third is the passive remedy when it comes to enforcement. So we follow those three steps. When you come to us under Section 10, or after the Article 34 decision by the tribunal, then as Emmanuel says, we look at it de novo. We don't look at it prima facie anymore. So if the arbitral tribunal rules it has no jurisdiction, then you can come to us at any time after that. We look at it. So I hope that gives you an overview of the Singapore position. There are some interesting cases. I don't think we need to go into those. We leave it to you to bring up your questions. But I would say this. Singapore law does look to English law, German law, Australian, French law, and then we decide if we follow or not. I think there are some issues that need to be decided on an international level, and it will be helped if we have bodies that come to a conclusion. Never, there is no such case as the right way. But everyone should agree, let's say, if it has been set aside at a seat, then there's nothing else to enforce, which is the English position. Unfortunately, it's the Singapore position. Or the International Tribunal should say, no, even if it's set aside at a seat, there's still an award to enforce. And I have some feeling for that, because sometimes the seat is a jurisdiction that gives one party certain advantages or disadvantages. So, for example, there is a case where I was counsel and we were forced to go to Arizona, and the arbitrator there decided, as the Americans sometimes do, it doesn't matter if you formed a company, you're the sole director and managing director and shareholder, you and your wife, so you are parties as well. So there's no incorporation of a company to shield you on liability. So why would you try and set it aside at the seat? You will lose. You can try it at enforcement, and the reverse can also be true, right? When a party takes advantage of somewhere. We are aware of all these dirty tricks. I was involved in a case where the party wanted an issue decided on a preliminary basis, that maybe 3/4 of the terms of the award were time barred. The arbitrators were very clever. One of them had been stung before, so he said, no, we'll deal with it at the end. And guess what that party did? They ran to their home court in Pakistan and got an injunction claiming misconduct. The arbitrator did not want to let me save costs. One of our arbitrators, was the arbitrator in Rupali. So we got stuck because the Supreme Court of Pakistan issued an injunction. And one of the arbitrators was a retired judge of the Supreme Court. So he said to the other two arbitrators, I'm very sorry, I live in this country, I have to obey that injunction. And then we had a issue with truncated tribunals. And this was in 1990. And I think because of our case and the representations made to the ICC, they amended their rules to give them power to appoint an arbitrator if one couldn't act. So as I said, we will continue to look outwards. We continue to look to other countries like France, and as well as England, Germany, to see the way forward, because we think that the more common platform we have, the better for the businessmen who need certainty. Thank you.
Thank you very much, Quentin, for this excellent presentation. Now we can take some questions. There is a microphone here and a gentleman there who can distribute it. Who wants to start? So we know your names, but for the record, you tell your name and ask the question.
Thank you very much, Emmanuel. My name is Jacob Grierson.
Just speak.
It is.
Yeah.
Excuse me, I've lost my voice, so I need this microphone. My name is Jacob Grierson. I am based in Paris, but I am English, so I was particularly touched by Emmanuel's warm comments about English, the English approach earlier. And so I'm going to try and get my own back by asking a question to Justice Loh. I was extremely interested in your explanation of the AJU case, if I got the name right, the one about public policy issues. It seems to me that the approach of the Singapore court in that case was very different from the recent approach of the French court, the Paris Cour d'appel, in the Bellicon case, where, I don't know if you're aware of that case, but obviously both of your co-panelists are, the French courts opened up and reversed a decision by a very eminent arbitral tribunal before whom issues of money laundering had been aired, who had an enormous amount of evidence, and then the Paris Cour d'appel decided, based on, in my view, very little evidence, that there had been money laundering. I'm wondering whether you think that that is a good approach. I assume not, given the approach that the Singapore courts have taken, and whether you think that's the sort of thing which is going to attract more people to do arbitration in Paris.
You must be a practitioner. Are you? You see, one of the dangers as a sitting judge is if I give my view and the next time a court case comes up like that, I'll have to declare I answered the question. So I say this first very clearly. I haven't had a case like that before me. I have not thought about a case like that with money laundering. And the third, these are purely my private views. So I don't know. But the point is, I think when it comes to public policy, money laundering is in a very gray area where most countries will accept that it's not acceptable. I mean, let's look at it this way. Would you come to me to enforce a contract that does trafficking in people? Clearly not. That would be something that would shock our conscience, and we won't have anything to do with it. We will declare something like that illegal. We will not allow enforcement in our country, perhaps. Money laundering is a bit of a gray area because until that's proved, it's a bit difficult to answer. Now, I had a case close to this, which not everyone agrees with me, and it's called Rakna, R-A-K-N-A, Rakna. There was this businessman who decided he had expertise, so he said, in providing security services for maritime ships, maritime industry and ships that traveled dangerous waters. I suppose he meant Somali waters. And it was a very serious concern, especially with insurers and valuable cargo. So he had these two ships, and they had all kinds of arms and ammunition on board. And he claimed he had a contract with this person who was actually the permanent secretary of the Ministry of Defense. So you come quite close to gun running. But then, at that point, Rajapaksa was the prime minister or president. And he entered into those, or his treasury secretary entered into a contract to do that. And then Rajapaksa, I think in 2015, lost his election. There was another president who immediately went after all these contracts. So the party that was aggrieved started an arbitration. And of course, the new government didn't have time to investigate. Was this really corruption? Was this gun running? Was it illegal? All they could do was cast aspersions. This must have happened. That must have happened. Nobody can buy this kind of arms unless it was corruption. But you see, they had no proof. And the arbitrators went ahead and ruled against them because the government did not participate. Halfway through, they sent in a letter to say, we've settled this, so you've got no more jurisdiction to carry on. The arbitrator said, come, let's hear why you say I have no more jurisdiction. That party didn't turn up. But the other side said, no, this is invalid, this MOU, because it's not been adhered to. They've gone and arrested my ship, they've gone and taken the ammunition away and the guns away, something like that. So the arbitral tribunal ruled, no, you didn't come forward, I'm going to hear everybody. So they did it very carefully, noticed at every step to the government, they didn't take any part in it. And of course, they got the award in their favor. Then they came before me to set it aside. And I said, set it aside on what? One, they said there was a settlement agreement. But my answer was, you didn't turn up at the arbitration, you didn't defend it, and the arbitrators ruled otherwise. And I see nothing wrong with their decision. Then the next challenge was Article 34. And again, the challenge was the arbitrators decided matters beyond their jurisdiction because it was settled. They couldn't come before me on illegality, corruption, or gun running because they didn't have any evidence. All they could say was A and B, who were the former go-betweens, have been charged. So I said, how long do you expect your trial to continue? And you mean I keep this in suspense until then? Eventually, I threw it out. And of course, I was criticized, saying, you know, being over-legalistic. I don't know if I've answered your question.
You have, absolutely. Thank you.
Good try. Jacob. You had another question? Brahim.
Thank you. Brahim Mouelhi, legal independent consultant, mediator, and beginner arbitrator. Emmanuel, with his honor, Dominique Hascher, you gave us a complementary, comprehensive, and very comprehensible view on the impact that the French thinking and practice brought to the benefit of international arbitration. What we are seeing these recent years is some threats that are coming from different parts towards arbitration. Some of them are from inside the arbitration system. A lot of criticism has been said during the few recent years. And some are coming from outside, and mainly from political areas, not only elsewhere, but also in France and in Europe more precisely. And you touched base on that during your addresses earlier this week. So how do you think that the French practice and thinking could help preventing these risks or these threats on international arbitration? Thank you.
We are debating who is taking the question. If I would leave aside investment arbitration, it's a big debate, and it's a completely different thing. I focus on commercial arbitration. And I have to congratulate the organizers of the Paris Arbitration Week to make sure that it falls exactly the week in which the Tapi case is heard. Because that's perfect timing for PR-wise, great publicity. You know, it was concocted long ago. Tapi is an exception. Everybody understands that even in France, some cases are different. So I don't think people really mind for that. And as to the internal threats, I think it is mainly a byproduct of the debate regarding investment arbitration. NGOs found a nice toy to play with, investment arbitration. Now that they have exhausted that toy, they are trying to take another toy, which is commercial arbitration. And maybe we can destroy commercial arbitration as well. I think the parties will be sufficiently vigilant and the courts not to indulge, but your comment, in fact, it's a question and also a comment, is well taken because we never can take anything for granted. You take the next question. Madam. Yeah. Depends.
Well, thank you very much, Salis Sawah. And actually, well, thank you for letting Monsieur Hascher answering. But actually, the question was for both, because, and actually also for Mr. Loh, because Monsieur Hascher, President Hascher, talked about the plurality of legal systems, including arbitration. And you have mentioned the English approach of helping arbitration and the French approach of protecting arbitration. And my question is more focused on Putrabali and Martin, which is very dear to the French academia and French courts. It's their pride in a way, and I'm aware of that, so I'm very cautious in my question. But as a practitioner, I had many problems with Putrabali, and I was always wondering, what is this international legal order that needs protection more than what French courts do for foreign judgments? And it was mentioned that international arbitration is also, well, businessmen, I heard businessmen at least twice. So this international legal order is based on the consent of businessmen, so not weak parties that need protection. And we always struggle on, we always discuss the seat of arbitration when arbitration agreements are concluded. So the seat is always a relevant thing, and a relevant issue to talk about and to think about thoroughly and profoundly. So I'm wondering, and in practice, myself, I've seen cases where the award was annulled, the parties restarted in another arbitration, but when the case, one of the parties was not happy with it, they came with the first award that was annulled to enforce it in France. And they couldn't enforce it anywhere else. So why this international legal order needs first protection? And second, why more protection than foreign judgments? And why, if this all counts, why the whole discussion about the seat of arbitration, if that doesn't count after all? Thank you.
Okay. Well, I think we may have to simplify things out.
Yeah, speak.
Works?
No, it works, but you just have to speak close to the mic.
Forget about the arbitral legal order for the moment. the question really was for the French court in almost all the cases we had that illustrated this legal theory, that we had annulments in the country of the seat for, let's say, reasons, motives, that were very parochial, were linked to the domestic approach of the annulment court, and do not really comply with acceptable, recognized standards of what annulment should be. And this is a way just to enforce awards that have been annulled in the country of origin for reasons that are, again, reasons that do not comply with international arbitration as it is conceived of today. So in the field of annulment and setting aside, even if countries adopt the model law, I mean, it's not a question of adopting the model law, it's what do you say under the model law? If you have the public policy exception, do you conceive it like the courts in Singapore as being very narrow, or do you conceive it like courts in, we had the example of India, but there are several other, certainly, examples that we could give, were just anything that the judge doesn't agree with as to the application of the law is contrary to public policy. So we are here in the situation that we had in the, more than half a century ago and more, when the arbitration agreement was usually held invalid for many, many reasons under national law. So just a way to, after all, give effect to the will of the parties. They have agreed to arbitrate. The Appellate Tribunal has done a task which is perhaps acceptable, we do not know, but what we know is that the annulment, at least, may come for reasons that are, again, linked to the view or narrow view of public policy at the seat of arbitration. That does not mean, I have to say, that if the award has been annulled in the country of origin, it's going to be automatically enforced in France. We never say that. You have to prove that the award which enforcement is being requested for the French courts meets with all our requirements on the validity of the award. And it is very likely that if the award, for example, has been annulled in the country of origin for a good reason, for example, the lack of impartiality or independence of the arbitrators, or the lack of arbitration agreement, or whatever you just named the counts under the UNCITRAL model law, or the New York Convention, well, it may well be then that we will find just the same. And that instead of enforcing the award, we will also determine that indeed, yes, well, the tribunal was not independent and therefore you will not have any enforcement. So it's just you have another possibility of enforcing your award here, but that doesn't mean that because the award has been annulled, it's going to be automatically enforced here. Okay, so I just wanted to make a very practical, give a very practical answer to your concern. Now, the problem is that we hear, well, how can you resurrect a deaf person? I mean, the award has been killed in the country of origin, so how do you find it alive? So here I give the floor immediately to Professor Gaillard, who is the the divinity who knows all about this.
No, but thank you for this gift. I appreciate your friendship. You said that it's your favorite topic. I think it's the favorite topic of everybody else when they want to criticize the French. Right? And also when you discuss the businessman and it's trying to reconstruct what the parties wanted, I think we will see more and more opportunities for that and for enforcement of annulled award in the coming years, because the trend is a legitimate desire for many countries to have arbitrations closer to home, if not at home. There is not a single oil and gas oil concession or oil and gas contract with a Nigerian party which is not in Lagos or Abuja, but in Nigeria, right? The oil companies accept that. That's fine. We can travel, we can do it at your place. Fine. Does it mean when you try to reconstruct their intent that they say, okay, but arbitration is just a first instance ruling and the Court of Appeal is the local court, and we will, after all, respect at the end of the day what the local courts will say? It boils down to that. I still do not believe today that it is respecting the Nigerian legal order to say, which I respect and which I like, but I can also say I respect you, I like you, appreciate, I'm happy to have an arbitration in Abuja, but I'm not prepared to say that because the court locally said the award is not good because they trespassed a deadline or because whatever, because NNPC lost, basically, that this decision should prevail over the award of the three arbitrators, having spent 3 years deciding on the issue. And I prefer to export. What should be exported should be the court decision as opposed to the award. That's the key question. And I think there are limits to trying to respect the intent of the parties, because I recognize that one party will say, the oil company, Exxon will say, I wanted arbitration. My intent is arbitration. And then the other party will say, but in Lagos, so it means that you have to do something with the court decision, right? I think at the end of the day, it boils down to a policy issue. That's why we can discuss it with a lot of respect for the other policy. It's a policy issue. Do you want to have the award circulate, or do you want to have judgments circulate? And I think when the parties wanted to have arbitration, then the right thing to do is to have the award circulate, not the judgment. Because if you have the judgment, then you have the next question. Let's assume that it means the judgment, fine. So it means arbitration in Lagos is just for fun, and then what really matters is what the Lagos courts will say about the award, right? And let's look at that. Well, okay, but when they say, yes, it's a good award, I don't set it aside, that's not good enough. So you still have to control at the place of enforcement. Why is that? Because you have legitimacy to control at the place of enforcement. In NPC 1, the Lagos court says, it's a good award, and I want to export that. And that's what the English courts are starting to do. Export the decision about the award. It's a good award. But why would, in that case, why would you control again? So you cannot say the court of the court at the seat has a transnational global effect if it says the award is no good, but it has zero effect if it says the award is good, right? So you have this kind. But if you can say, okay, fine, what's the English courts are starting to do? I want to apply the logic to the end. So I look at the judgment, good or bad. But then you have this problem, which I expressed, the race to the court. And we see a lot of that. It's open to manipulation. I think it's a bad system policy-wise. But again, we are talking policies. We're not talking right. It's not like one cannot say it doesn't exist or it exists. It's a legal fiction. The question is, do you look at the judgment or do you look at the award? The award is still there. The award has been rendered, right? It's still a legal act rendered by people. So you cannot say it doesn't exist. This is a childish argument, I would say. The real argument is a policy. I prefer the court decision, and that's what should circulate. But I'm saying that's a logic which, in many ways, with the Gilets jaunes and all that, we are in the 30s. That's a 27 Geneva Convention logic with the double exequatur. So we are back to square one. So I say, when it comes to the shift between arbitration and the courts, those courts who should look at it and are of a proper title, legitimacy, if you will, to use contemporary language, the most legitimate courts to look at the award are the courts which are going to say, yes, you can attach the bank account, i.e. the enforcement courts. And if you have just an arbitration in Beau Rivage, in Lausanne, because you're a very sophisticated party and you know it's the best place in the world to have an arbitration, but you don't want to enforce your award in Switzerland, I don't think it's a Swiss award. I think it's an award rendered by Rusty Park, by Pierre Mayer, and by Justice Loh, and it's an international award which will be controlled where it should be enforced. I mean, but again, I don't accept the childish, it doesn't exist, it's completely empty argument. I accept the policy argument. What is it that we want to do? And when it boils down to the policy, then you look at what's going to happen, and are we going to say that when the parties said arbitration here or there, it means that really it's a local thing. I don't accept that. It's not the logic of the New York Convention, and I don't think it's a good policy, but the debate is wide open. Other questions? Veronika?
Thank you very much, Veronika from Essex Business School. Thank you very much for the very interesting and rich presentations. I would like to pick up on what's been said about the substantive law approach and the validation principle of French law and try and apply this to a post-Achmea intra-EU bilateral investment treaty situation with an ad hoc tribunal seated in Paris. I would be interested in your views as to what the tribunal should decide in relation to an objection to its jurisdiction based on the idea that the offer to arbitrate was invalid, hence could not be accepted by the investor, and there is no valid agreement to arbitrate. And assuming that the arbitral tribunal, seated again in Paris, renders a decision on jurisdiction finding that it does have jurisdiction irrespective of Achmea, how would you say would the Court of Appeal in Paris look at a challenge brought by the respondent member state on the basis of the same argument against that decision on jurisdiction? Thank you very much.
Well, I go first, but I was certainly, I'm incapable of answering the whole question. If you look at the investment tribunals that even after the Achmea judgment was made, have had to deal with the issue of their jurisdiction, I understand that they have, for the moment, upheld their jurisdiction. So that's a possibility. So now the second stage of your question is, how would the Court of Appeal of Paris decide it? Well, why don't you ask them? Well, you've got lawyers here. I'm sure they will make you proposals to defend the award. Thank you.
Yeah, there is nothing against the French law vision to recognize that either at the seat, if France is the seat or the place of enforcement, the existence of the arbitration agreement, public policy, among other things, the very narrow grounds, will be controlled. So I have nothing against, there is nothing in principle against having the French court say, has the state consented, and is this consent valid under the law applicable to that consent, which is the French way would be look at the consent itself and not go through the detour of international law or any other legal system or any other proper law, right? But in Then what the answer to the question should be is a different matter. But your question is a methodology question, as I understand it. You know, would the French have a magic solution saying, well, this is valid, I don't look at it? No. In the same way, in commercial arbitration, you look at the existence of consent and its scope at the time of the review or at the time of the enforcement. A dialogue doesn't mean I accept blindly what you say. It means I'm going to accept an award in my legal order. I'm going to check a number of things, right? Then how do you implement that in the post-Acmea situation goes beyond your question even, I think.
Thank you. My name is Natia Gvalia. I'm from Nanterre University. Thank you for organizing this event. It's very useful and beautiful event. Thank you. So my question is, let's say a party does not participate in arbitral proceedings and is literally sabotaging the case. So what are the chances for such an arbitral award to be enforced? And if a party can rely on the state court or juge d'appui to enforce such an award? Thank you.
Quentin, do you want to answer that?
This is state investment arbitration.
No, it's a guerrilla tactic. I can start if you want.
No, why don't you start?
So, default is not going to help the party which defaults because it can proceed. Everybody would agree, I guess, more or less, that the arbitration should proceed, and then the default is not going to help. Now, the French view is, and that's also in your question, is can you say, well, there is a default, I need a juge d'appui, I need a judge to help me? That's resorting to the old, I think, English view, which is you need a judge. If you have a problem, you need a judge. But the French answer to that would be no. You continue before the arbitral tribunal. We recognize that default does not stop the process. We will enforce, because due process, which we control, doesn't mean that you have to have participation. It means you have to have had an opportunity to participate, and that's good enough. So in many cases, the French answer would be, you don't need me, you don't need the judge, you don't need any judge. It's good enough. The process is self-regulated.
Yeah, I mean, I would just add that's exactly what I had in this Ragnar case. The party refused to turn up. It didn't answer anything except midway. It just said, we've settled this matter. So immediately, the claimant said, I want a hearing, fix a date. They proved that they served it on the respondent. The respondent didn't turn up. The arbitral tribunal heard the party and ruled. You don't need the court. And I don't have jurisdiction to go and tell the respondent, you better turn up. I can't do that. But what I can do is when the claimant has got an award and the respondent then tries to sabotage the result, I'd be very careful to see and to make sure I don't help him do it. Because if due process was observed, you chose not to come, it's too bad. You've got an award against you.
Professor Besson, you have a question? I'm sure you have a question. If you have no questions, you have to beware, because I can ask questions to you.
Hi, Maximin de Fontmichel from University of Versailles. I had a question for Dominique Hascher. Do you think that the division among French scholars regarding international arbitration, or there's not such unity as before regarding the international arbitration sphere, has an impact on how you judge and how you create international arbitration law? Because it seems, from my point of view, that in the 60s, 70s, 80s, and maybe afterwards, there were quite a unity among arbitration scholars, and now it's more like divided. So there's, this division has an impact on the Première Chambre civile.
Well, it's difficult to say that it can have any impact. It's true that there is no that there is a lot of I can't even say debate, because I don't think there's a debate. There's a view. There's a legal thinking, legal scholars, writers that have worked to promote international, even arbitration in this country, coming from nothing, and from a view, from traditional views that if we had to follow them, arbitration would have not existed. It's thanks to these people that you are sitting in this room today. Otherwise, there would be no arbitration week here. I have said that these were the most regressive circles of French academia. I read them. That's fine. It stops there. As to their influence, I think if we had to, it would mean that we will have to change entirely our system, that we will have to get back to a conflictual approach, that we will have to go back before 1960. Well, you have proponents of that. Look at the Ekmeyer judgment. Thank you.
Thank you. Good afternoon. My name is Guillermo Salcedo. I am an independent consultant. I have a question for the three members of the panel. It's fascinating to see with hindsight how French arbitration law has influenced other countries. But looking towards the future, if I may ask to each of the members, which topic do you think is going to be the next one that's going to have a big influence on the world?
Sorry?
Which topic do you think is the topic of French law? We just discussed that Poutravalli and Hill-Martin, with the enforcement of annulled awards, was, let's say, chronologically the last big influence in French law. Perhaps you could comment on what will be the next topic.
Well, personally, I think that the current debate, and will remain vivid for a number of years, is the negative effect. What I have called the negative effect of competence, which is the prima facie versus full control at the beginning of the process. Because that's a big debate. It's the world is divided. Positions are pretty entrenched. And it's going to go on for some time. I'm very happy to see that a number of countries have embraced the principle, especially when I see that, if you look at Asia, for instance, Hong Kong and Singapore, the two most pro-arbitration countries, have endorsed it wholeheartedly. This is no coincidence. It's their policy to be super pro-arbitration, and this rule is a flag. It's a vote of confidence for arbitrators. You can decide all kinds of things. You can decide your competence. If you get it wrong, I will be here, but later. Because if not, I'm going to have a gateway to speak like the Americans for every arbitration. So maybe one arbitration needs to be protected. Maybe one signatory of a clause has never consented. Maybe it's the janitor who signed the arbitration agreement, or someone with no authority, or whatever. It may happen. But we say, because we have a statistical view of the world, or a sort of intuitively statistical view of the world, we say it will happen once in 1,000 cases. Now, in every case, if you say to save this situation, we need gateways, then every arbitration will have to go through gateways. So you sacrifice every arbitration for this case, which we think may exist, but will be an anomaly. Do we sacrifice it? No, because you can catch it at the end. Or if the arbitrators do not catch it, after all, we can catch it. If you trust them to decide public policy matters, you trust them to decide very important things, why not the scope of their jurisdiction? It's not more important, it's a private issue. Right? So that's I think that's the debate. And frankly, those who are obsessed with the seat like to talk about Hill-Marten and all that. It's anecdotal, I say. Although it's reasonably important, and if you were to see, I'm looking for the next study from not a legal standpoint, from an economic standpoint, if you look at the spread of the seats in the world, the arbitration is going to take place everywhere. What are the interests at stake? What's happening? And what I don't like in the solution, which is, okay, we can always catch it through, if it's a bad decision, we can catch it through by throwing away the judgment about the award, because we are going to control that, right? So if you believe in the seat, that's your fallback position. But what's a problem there is that the more liberal you are, in private international law thinking, we should be liberal, we should recognize international decision, we should trust the judge, we should lower the bar, the more anti-arbitration you become, right? So you're more open to the world, I recognize judgment very easily, I lower the bar. And I'm more anti-arbitration, so the more favorable I am to foreign elements in my system, the more anti-arbitration I become. It's a problem. So that's my view. But I don't think this topic is blown out of proportion completely. It's a good test of a system, and what they look at, but I think it's blown out of proportion. Yes. Yas Banifatemi.
Thank you. Yas Banifatemi. I was really interested by a sentence, Justice Hascher, that you said, which is that the courts do not have the monopoly of justice. And if I may, at this late hour, I don't need to reopen everything, but when I look at the underlying assumptions of the gateway issue and the way that some practices are looking at these issues, it does sound like the underlying assumption is that the arbitrator is a child in need of a parent, given an authorization, un mineur sous tutelle, and therefore, if the judge says you can, now I authorize that you do this, this is the gateway, then the actual dispute will be resolved by the arbitrator, and then it may go back to the courts. So there's this is really where I see the difference between a philosophy that looks at the arbitrator as not in full power of adjudication and in need of another authorization in order to do that work and to proceed with that mandate. And the other view, which I think you expressed, but I really would be interested in hearing your further views on this, on arbitrators are just, and this is Putrabali really, I think, that arbitrators are just adjudicators as any other adjudicators such as courts, and that monopoly is not the monopoly of the courts, and therefore it's something that arbitrators can do just equally with a potential control at the end. So a long sentence just to ask perhaps if you would care to expand somewhat on that sentence, which is that the courts do not have the monopoly of justice.
Well, thank you. You almost answered your own question for me. Yes, we are acknowledging that international arbitration is a system of adjudication of its own. We are not, it does not has, we don't, when an award is made, it has res judicata, for example. You don't have to bring it to the court to get a special authorization to make it valid. Enforcement might be something else, but we generally, the French arbitration law is built, well, as Professor Gaillard said, there is no interference with the arbitration process. We think that this is a self-governing process that should unfold according to the parties' consent and according to the orders of the tribunal without the national courts interfering. I mean, all our rules are pro-arbitration minded. And if that's an answer to you, to the question that came from there, and if I may, to the question just before yours, is which rule of French law will jump out of this country and go to other, will be accepted by other legal systems? I don't care about which rule. I think each country has its own legal thinking. They are not obliged to recognize an arbitral legal order or other. What we are perhaps, I hope, doing is try to transmit to others the fact that national courts should have a pro-arbitration stance. I think if we had to deliver a message to others, I think that's the only message that they could take from us. How they do it afterwards, after all, we don't care. What we care is, what is important is that the arbitral awards will not be disturbed because of questions of the law was not applied by the arbitrators, like the courts thought that it should have been enforced, or that arbitration agreements should be questions of jurisdiction should have to be first fought between before the national courts before there's an opportunity to get to arbitration. I mean, all this was we've been discussing since the beginning. Thank you.
To respect our promise to the Barreau de Paris, we have to adjourn in a few minutes, literally. But we have a last question in the back, and maybe we call it tonight. Sébastien.
Yeah, Sébastien Manciaux, Université de Bourgogne. I have a question for Justice Loh on the Article 5.1 of the New York Convention. I would like to know what is your interpretation of this provision, recognition and enforcement of the award may be refused. Point E, if the award has been set aside at the seat, may be refused. So to read it otherwise, it means may be granted even if the award has been set aside at the seat. So what is your interpretation of this provision?
I think Singapore has taken the view, and I'm bound by the Court of Appeal, that has said very clearly that if the award has been set aside by the seat, there's no other award, there's no more an award to enforce. Will we ever have to reconsider this? Speaking as a student of the law, yeah, sometimes I think you need to consider this again when circumstances come up. I've always worried about the case where an award has been validated at the seat from a system that is known to be corrupt. I think you had the Paris Court of Appeal had this problem at one time with the Russian arbitration. So what does a court do if there was a valid arbitration award in the seat and the party then went to the court at the seat and set it aside? And you know that system is corrupt. I think inside you, any jurist, any student of the law would feel this is not right. This is certainly not right. Justice wasn't done. Technically, you have the view, technically you have the avenue. You can try and bring up corruption, but you know, that's something that's very difficult to prove. So currently, unfortunately, we belong to the group that say if it's set aside at the seat, there's no more award to enforce. And I think one of the reasons our Court of Appeal said was, if we look at model law, it seemed to indicate that that was a possibility. And so they took it that way. And I think Hong Kong has followed us. London, no, sorry, we have followed London, English law and Hong Kong law.
Thank you. I want to thank again both the judges and especially Justice Quentin Loh for having traveled so far and come to educate us about Singapore, which is probably the best and the most pro-arbitration legal system in Asia, if not in the world today. So Switzerland and France are pretty much on an equal footing now, once you cure this last hurdle. And thank you also, Dominique Hascher, for your words of wisdom. It's really a great debate. Thanks to all of you. I really personally enjoyed the debate, so thank you for your presence and participation.